Ladies and gentlemen, I said to the workshop conveners that I'd like to keep it very informal this morning, so perhaps you could ask me questions. But just to very briefly highlight to you the recent history of Fijian experience with anti-corruption measures. That started off with the creation of the Fiji Independent Commission Against Corruption, which was in 2007. And soon after that, Fiji acceded to UNCAC, the United Nations Convention Against Corruption. Ironically, somewhat ironically, the accession date was 14th May 2008. 14th May, as most Fijians would know, was the first coup in Fiji, which many argue, in fact, led to or precipitated the downfall, if you like, of good governance. It's led to a number of financial mismanagement issues. It threw out the development plans that we had, and of course there's a period of non-accountability. And indeed, I think that culture still resonates in many sectors within society, including many sections within the public service. So therefore, it was critical to set up the Independent Commission Against Corruption. The impetus for that, in terms of the actual law, came from ICAC, the Independent Corruption Commission from Hong Kong. There's some slight differences. In Hong Kong, the ICAC does not actually have the prosecutorial powers, whereas in Fiji, FICAC does. One of the reasons why we had put that in was to take into account some of the issues that existed with other prosecutorial agencies. So in a way, FICAC does keep a check on other prosecutorial agencies. At the same time, they can also keep a check on FICAC. FICAC does report directly, as far as the law provides, to His Excellency the President, who was here, as you know, who opened up the workshop. Annual reports are to be presented to the President. It does, as provided from the new Fijian Constitution, it has a charge over government finances. So in other words, I think Section 154 that says that government must always make sure that FICAC, including some of the other independent agencies, always have sufficient funds. Because the logic behind that, of course, is you could throttle an independent commission by not giving it enough money. So if you always have the right amount of money available, then it's able to do its job as it's supposed to do. So that's essentially what happened with us. In 2007, apart from the creation of the law that led to FICAC's existence, another law was put in place, which is the Prevention of Bribery Promulgation. The Prevention of Bribery Promulgation also set some very new offences, in particular pertaining to civil servants. So, for example, Section 10 of POB has a section on unexplained wealth. So we, for example, when we appointed in 2007, you had civil servants who were probably on the salary of about $25,000, $30,000 a year, but owning about 7 homes. They definitely did not inherit it, as we found out, from any grandparents or their father or what have you. So they obviously we needed a position where if I am a civil servant earning X amount of dollars, and if I accumulate assets, you need to be able to be in a position to explain how you accumulated those assets. So the burden of proof was in fact shifted on to the civil servant. So as opposed to the state actually having to prove that you've acquired it through illegal means, you actually have the burden of proof was on you to explain how you got it in the first place. So these are some of the measures that were put in place. Subsequently, we, of course, as I said, we had ratified UNCAC. But one of the things we did, I remember in the first meetings I went up to Austria, where, of course, DC is based, is we volunteered to put ourselves up for the peer review program, which essentially meant that Fiji, put up its hand and said, we've ratified UNCAC unreservedly without any reservations to any of the provisions in UNCAC, but please come and review our performance in terms of compliance. So in fact, I'm just trying to, with the first 2 countries, and normally they partner up, the first 2 countries that came in reviewed Fiji's performance was France and Serbia. So they were here, in May in 2009. And then in 2011, USA and Bangladesh came and did a peer review of us. Subsequently, they were very happy with us. Fiji then was asked to peer review other countries. So we have since then, in 2012, we, together with Namibia, peer reviewed Timor-Leste. And then in 2015, which is this year, earlier this year, some of our staff actually were stuck in Nepal because the airport had closed down for 14 days or so. Together with Benin, we peer reviewed Nepal. And then we, together with Brazil, are at the moment peer reviewing Antigua and Barbuda in terms of their compliance with UNCAC. What we found is that it really helps upskill your own staff, knowing about UNCAC and knowing about the pitfalls and the shortfalls. So it does provide us, a particular level of knowledge base that exists within the country. And we'd like to thank, of course, UN and Anya's assistance in that too. All the staff in our office love her, and they think she's always very, very helpful. But that's some of the things that we've done at the international level to build that capacity. Of course, as I said, FICAC is an independent body. It has its own finances. It does have a commissioner's position, a deputy commissioner. Fiji does not have a commissioner at the moment, but the Constitution essentially provides for the deputy commissioner fulfilling the role of the commissioner. Unfortunately for Fiji, in the period from 2007 up till the elections, and to be frank about it, our friends Australia and New Zealand weren't very generous to us. So there was a number of travel bans that were placed on anybody that got appointed to various positions. We had identified a very eminent lawyer from Malaysia to become the commissioner. And upon accepting the position, he then pulled out because he thought he might be subject to travel bans, traveling to Australia, etc. So since then, we have not appointed anybody to the commissioner's position, but the deputy commissioner has been actually carrying out the work, and as I said, legally, he's the capacity to do so. I think overall, as I was discussing earlier on this morning, before I open up the floor for any questions, overall, I think it is Fiji is in a very unique position where we have a number of measures now that's in the Constitution, apart from FICAC, and as you know, with the Auditor General's Office, and we have other organized bodies that have been created, like the Accountability and Transparency Commission. The Commission is actually appointed by the Judicial Services Commission that appoints judges, etc. Under the Accountability and Transparency Commission, the Commission actually must receive from members of Parliament, including ministers and public office holders like His Excellency the President, the Prime Minister, etc., the declaration of assets. So if you hold those positions, you have to declare assets. There's some laws that are being built around it. So that becomes made available to the public. So anybody can walk off the street and go to the Commission and see how much I'm earning, what's my balance in my bank. So every year, there's that need to declare. Of course, if my bank account says I've got $50,000 cash, and the next year I've got $1 million, obviously something funny is happening, and the Commission has the ability to then carry out investigations, and of course refer the matter to FICAC if there is a need to do so. So that is we've never had that before. So that's a new body that's been put in place. We now, of course, have FICAC. We, of course, have the Auditor General's Office. One thing I must say is that at the moment, FICAC's role is limited to commissions of acts that emanate relating to a state-owned enterprise or government itself. It does not address the issue of private sector corruption. And that, I can tell you, is quite widespread. There's a joke in the private sector that if you are the purchasing officer in a hotel, you probably have the best home because you can go and a hardware company, a grocery store, whoever it is, you may actually purchase from them on the condition you get 10% of whatever value you're giving to them. So I think private sector corruption, I think, still remains a bit of an issue. That, of course, sometimes spills over into private-public sector corruption, and that's where FICAC comes in. That's where other bodies can come in and, in fact, investigate. But private sector corruption, there is absolutely no way to address that at the moment, unless, of course, it turns out to be fraud. Then you report it as a criminal matter, and that the onus is then, of course, on the employer to do that. I think as I was talking earlier on, before I started, the issue about parliamentary bodies having a separate standing committee, as I said earlier on, I have certain reservations about that, because I think you need to have a particular level of understanding of the need to be completely apolitical when you're dealing with matters of corruption. So there's a particular level of political maturity that is required. You should not see the standing committee, or members of the standing committee should not see as a mechanism of political point scoring. And I think that level of maturity, perhaps, in my humble opinion, does not necessarily exist in Fiji at the moment. So the focus, I think, should be from now, until a period of time, is to strengthen the independent bodies, make sure the commission is up and running, is to ensure that FICAC has enough resources to carry out the education and the public awareness about issues of corruption. And I've got the annual report of FICAC here. I brought it with me. And if you see, they've actually highlighted, they've broken down all the complaints they receive, etc. Now, in fact, they've done a good job, because if you see majority of, I don't know whether it's in this particular report or not, most of the previous reports, majority of the complaints that FICAC receives aren't actually corruption issues per se. A substantial amount of the issue is to do with administrative mismanagement, in the sense that people have been very late in their responses. So because people get very frustrated, they go running off to FICAC, because the specter of FICAC coming in and giving you a phone call is not, most departments don't want that. So you'll see that there needs to be obviously a particular level of understanding what is corruption, what falls outside the area of corruption. And I think as far as the Fijian experience is concerned, we need to strengthen up these institutions. There's absolutely, I think, a lot of merit in the sharing of information between members of parliament within the Pacific to understand more so about corruption, what are the issues. I have certain issues, for example, at the moment with some of the matters that are emanating from the Public Accounts Committee. I think some members of the committee are not actually sticking to, for example, the Auditor General's report, but going outside the ambit of the Auditor General's report. And that is, in fact, if you look at all standard conventions on Public Accounts Committee work, that is outside the normal convention of what PAC is supposed to do. The idea is to look at processes and how those processes are implemented. I think, so that, given that situation, we need to be able to strengthen those very institutions. I mean, similarly with the Auditor General's Office, similarly with FICAC, they themselves as institutional bodies need to understand what specifically are their roles. Are they going to simply use it for some other purpose, as opposed to sticking to what the law states and within the premise? Because I think by developing that particular level of focus, you then give that institution a lot of mana, a lot of credibility and integrity. And then you can sort of move forward with it to be able to create a very sort of respectable debate and inquiry into areas of corruption. So, ladies and gentlemen, that's my little spiel on this. But I'd like to, stand here, and you can ask me any questions on that. One thing I think that is very important also, when we redrafted, we had a penal code that was about over 100 years old, which we inherited from Queensland during the colonial times, which in fact came from India. So the offences pertaining to abuse of office and corruption, etc., was very, very limited and absent, in fact, in some instances. What we did was, if you look at, I think it is Section 140 of the Crimes Decree, the commissioning of the offence and the gain of the benefit regarding abuse of office now, in Fiji's case, extends beyond the geographical jurisdiction of Fiji. So we can have a transaction, for example, between a public official and a private sector official taking place in Sydney, or the gain may be actually received in Sydney, that law still covers that. And I think that is very, very important. Because as you know, nowadays with the ease of travel, and the ease of able to move assets, etc., across borders, in your specific laws, you need to look at that. In Fiji's case, for example, in this particular area, and for example, regarding offences pertaining to computer crimes, it has to be cross-jurisdictional. So the commissioning of the offence can take place in another jurisdiction. I think the other areas that we have looked at is to be able to ensure that other laws do tie in with that. So our Companies Act, for example, has very onerous provisions now regarding directors' duties and fiduciary duties to the particular company, but also now that extends to state-owned enterprise directors. We had, the Fiji National Provident Fund, which is the largest cash holder in Fiji. It has about 38% of the entire cash reserves in Fiji and wealth, was run abysmally to the point where we had independent studies that highlighted that all our pension funds would have finished by 2052, the rate at which we were going. And the type of investments that were actually being made by the Superannuation Fund was quite phenomenal, in a very negative sense. So there was a lot of lack of accountability, and also by the directors themselves. So now with the Companies Act coming into play, which with the commencement date will start very soon, that creates another level of accountability. So we must understand that you can't just have one single law that will address this specific issue. You must have a network of laws that complement each other. So for example, now under the Companies Act, when companies file annual returns, in Fiji, for example, when a company filed an annual return, you had to file that on an annual basis. But if you didn't, the penalty was $20. So you have companies that have not filed annual returns for the past 20 years. So somebody comes tapping on your shoulder, says, all right, 20 by 20 is $400. I'll pay the $400 and file the annual return. But now also companies have been broken down into different in different categories. So you actually have to disclose your financials in the annual return. So the Fiji Revenue and Customs Authority can actually cross-reference that in terms of what you file in your tax return and what is filed at the company's office. So these are the kind of complementary type of laws you need to look at in order to help your respective countries too, which is what we're trying to do. So thank you very much for that, ladies and gentlemen, and I'm quite happy to take any questions. Thank you.